Hello and a very warm welcome. My name is Upma Avasthi and today we are going to be discussing yet another fundamental concept to the law of contract, and that is acceptance. Now students, before you watch this video, it is worthwhile that you please go and watch our video on the overview of law of contract and our video dedicated to the concept of offer under the law of contract in order to gain a better insight on the concept of acceptance. Now, before I begin with this session, I'd like to say the most fundamental aspect to a contract is one party making an offer and the other party accepting that offer, and thereby the conditions of consideration, contractual capacity, and legal obligations follow. So, now we are going to specifically be discussing the rules that guide a valid form of acceptance. So, let us begin with this session. Now, as the slide tells us, now, if A is making an offer to B that he is willing to sell his car for a sum of rupees 5 lakh. Now, when B accepts to pay rupees 5 lakh for that car, then it is going to amount to a valid acceptance. So, it is going to be an acceptance for the same car that is being offered by A and for the same amount that is being quoted by A. Then there is going to be a parity between the offer that has been made and the acceptance that has been made, and this is exactly how the concept of acceptance works under the law of contract. What are the elements of a valid acceptance? The very first point on the screen tells us consensus ad idem, which means meeting of minds. Now, when one party makes an offer and the other party accepts the offer, it is really important that they should be agreeing upon the same thing in the same manner. That is, there has to be a meeting of minds, or another word that is used is a mirror rule. That is, the offer and acceptance have to be replicas of each other. Now, say for example, if A is making an offer to sell his car to B for rupees 5 lakh, but B, however, does not know exactly which car A is talking about. A could be talking about his SUV, but B might be confusing it for his sedan. So there has to be meeting of minds, there has to be absolute clarity. Acceptance should be made exactly for those things which are included in the offer. Then the next concept, which is a natural consequence to the first element of consensus ad idem, is absolute and unqualified acceptance. What I mean by absolute and unqualified acceptance is when A says that I am going to sell my car to you for rupees 5 lakh and B says I am ready to buy your car for rupees 4.5 lakh. Now in this case, this deviation of the quoted price from 5 lakh to rupees 4.5 lakh is not going to amount to an absolute and unqualified acceptance. The minute there is any change when the other party is making an offer, it becomes a counter offer. So you have to accept the offer as it is, and only then you can denote it to be an absolute or unqualified offer. Then who is allowed to accept the offer that has been made? So in this situation, either the acceptance will obviously be given by B to whom the offer has been made, or he can authorize his agent to make the acceptance on his behalf. So if A makes an offer to B that I am willing to sell my car to you for so and so price, then B can authorize another individual as his agent to give acceptance on his behalf. So it's either the person to whom the offer has been made, that is the offeree, or his authorized agent. Now another thing is silence cannot be equated with acceptance. So if I say that I am willing to buy your house for rupees 15 lakh, and if I do not get a response from you, or if I do not hear anything from you, then I am going to presume your silence to be a yes. Now in this case, if the other party does not respond as per the offer and later on the other party sells the house to a third party, in that case I will not be in a position to enforce the contract, because the law of tort says silence can never be equated with acceptance, even though the terms of a contract stipulate so. And there can be a time frame for giving acceptance. Now, it has been discussed in our video which talks about offer, that if you do not respond within a reasonable time, then the offer itself will lapse. So in the same way, when you are making an offer, then you can designate a specific time frame that you have to respond to us within a period of 1 month. Say for example, I get a job offer and I am supposed to give my response about whether I am interested in taking up that job or not within a period of 1 month, and I decide to respond after a period of say 1.5 months, and by that time if they have given that job to someone else, then I cannot say that I have made an acceptance of the offer and now I should be the one getting the job. The court will completely reject my contention, because I was under a duty as per the terms of contract to respond within the stipulated time of 1 month. And where there is no time stipulation, then the court will look at the standard of what would amount to a reasonable time in that situation. Finally, mode of communicating your acceptance may also be specified at times. Sometimes the party that is making an offer may say, okay, a verbal acceptance will be enough, or they might say that you have to give your acceptance in written. Then they might give a further condition that you will have to send a registered letter when you will be making the acceptance, or sometimes acceptance can be made through an email. So the mode of communicating your acceptance may also be specified, and in case you do not respect or you do not go by that term stipulation, then the other party is free to not oblige you with fulfilling the contract. So whatever mode of acceptance of a contract is mentioned, you must follow that mode. Now, we talk about another situation, offer and acceptance by post. Now, there can be a situation where instead of a verbal communication, you are making an offer and accepting an offer by posting a letter. Now, in this situation, when will the offer be complete? So, let's take an example. A is making the offer and B is accepting the offer. So, the first question is, when will the offer be complete? So, the minute A posts the letter and it reaches B, at that time, the moment when it has reached B, offer has become complete. The next question is, when will the acceptance be complete? The minute B will post his letter of acceptance, acceptance will become complete. Students, please pay attention that when we are dealing with situations where offer and acceptance is being made by posting a letter, then please remember that till the time the offer does not reach the other party, offer does not become complete. But it is different for acceptance. The minute that party will post its letter of acceptance, whether it reaches the offerer or not, it will become complete. Now, when will the contract become enforceable? Now, the minute B, which has posted its letter of acceptance, has done this job, then acceptance is complete, and the minute acceptance is complete, the contract is going to be enforceable. So when A writes an offer letter to B and the letter reaches B, then B posts the letter of acceptance. At that time, the contract becomes enforceable by B, that is the person who has accepted the offer letter. Now, whether it's revocation of the offer or revocation of the acceptance. If A has written a letter to B making an offer, then if he wants to cancel or take back that offer, he will have to write another letter, or he will have to come up with another mode of communicating cancellation or revocation of offer before the letter of offer reaches B. Similarly, if B, who has made the acceptance of the offer, wants to cancel or take back this acceptance, then it will have to make sure that before the letter of acceptance reaches A, it has to communicate its cancellation of acceptance. So very simply speaking, whether you want to revoke your offer or your acceptance when it is being done by post, you will have to come up with a way to ensure that your letter of revocation of whether offer or acceptance reaches before the original letters of offer or acceptance. And friends, with this, we have come to the end of our discussion on the topic of acceptance under the law of contract. Please keep sending us your feedback. Thank you very much for your time and take care.